This webinar is hosted by the Academi Heddwch Cymru, Welsh Peace Institute, and my name is Colin McInnes, and I'm the research lead for the Academi Heddwch. Before we go any further, I'd like to thank Steve Hollingworth. This is very much a result of his hard work and commitment to this issue, and I'll be handing over in just a moment to Steve to run this webinar and the webinar week today. But before I do that, just a brief word on the Academi Heddwch Cymru, what it does, and why we're particularly pleased to be able to host this event. This is the UK's first National Peace Institute. It's funded by the Welsh Government, but is independent of the Welsh Government, and we're very grateful to the support, not only from the government, but from all sectors of Wales, civil society, universities, etc., for the support they've given the Academi Heddwch. It does three main things. Firstly, it undertakes research, and this is very much part of our research brief. It undertakes research both within Wales, but also with international partners, and it's research for a purpose. It's not, although it can sometimes be blue skies research, it's primarily geared towards more application. Secondly, we're engaged in education from schools through further education, higher education, into lifelong learning, to try and develop peace in the curriculum at all levels, and to engage the people of Wales and its communities in thinking about and acting on peace. And thirdly, it's about protecting and promoting the heritage of peace in Wales. And some of you may be aware, but I suspect many are not, of a fantastic Welsh Women's Peace Petition, which celebrated its centenary last year, and is a remarkable early example of civic action to try and encourage peaceful results. If you're not aware of it and are interested, there's loads of stuff on it on the website, the Welsh Women's Peace Petition. Our ultimate aim is to establish Wales as a nation of peace, and we're very much engaged with Welsh Government and others in Wales, and are about to launch a report on this, which we will happily share with participants, or if not, have a look on the website. It's going to be a couple of months before it's finally finished, but we're very much there. We're hoping to declare Wales, or start to move towards Wales being the first declared nation of peace in Europe, possibly worldwide. You will have heard just a moment ago the recording is in progress. For the participants, the speakers, that means that when they speak, they will be recorded, and this will be available subsequently on the Academi Heddwch's website for those of you who may want to go back to it, or if you want to refer the discussion on to other friends, colleagues, etc. But if you're just attending this, you're not speaking, don't worry. You feel free to ask questions using the Q&A function, but the video will not show you or yourself. It's only the participants who are being recorded visually and orally, so don't worry too much about that. Okay, so I've got nothing more to add. Well, I've got lots I could add, but nothing I feel I should add, because we're not here to hear about me. We're here to hear about Steve and the other participants on today. So hand over now to Steve. Thank you very much, Steve.
Diolch yn fawr iawn, Colin. Diolch yn fawr I Bethan hefyd. Croeso I gyd, croeso cynnes. I'm very, very grateful to all of you at the Welsh Academy of Peace, and very, very proud to be associated with this event. So thank you all very much, and a warm welcome to everybody. Colin, thank you so much for highlighting just how committed Wales government, Wales civil society is to the issue of peace. I think it's really noteworthy in the current context that we're in. And so congratulations, and hopefully we can all help to make that a reality. A little bit about the logistics. There are going to be two webinars. One's today. The next one is the same time next week on the Tuesday, the 11th. We're going to have 6 speakers altogether in the two webinars. Next week's session will last a little bit longer, about an hour and a half, and I'll explain why. If you do have questions, please put them in the Q&A for responses. Thank you so much. My professional background is in international relief and development, and international humanitarian law has guided a a lot of the work that I've been involved with. And international humanitarian law really provides the framework for distinguishing between civilians and combatants, for really promoting the idea that conflict is done in a way that's proportional to accomplishing war objectives, not inflicting excess pain. And then finally, it's committed to the idea that there should be humanity during armed conflict periods. And so we have daily reminders now of just what an unacceptable price war is exacting on civilians, on innocent civilians. And while the cost of loss of life is incalculable, the survivors too lose in so many different ways with the systematic deprivation of so many needs and rights. Indeed, their needs and rights are primary casualties in conflict. Colin noted the number of wars. It's little discussed, but the number of war dead this past year is really in excess of what the number of war dead was during the period of the major Rwandan crisis. And these conflicts in Ukraine, in Palestine, Israel, in Sudan, in the Sahel, in Myanmar, in DRC, some of them are in our news, many of them are not. But it raises a whole array of issues and questions, I believe, that the international community has to address. How are losses going to be compensated? Who is going to compensate them? How can we restore justice and peace, lasting, sustainable pieces in these regions where so many people are suffering? And we need to find answers to ways to address the root causes of conflict, the grievances and the fear, the stereotyping that continue. Some victim compensation efforts have been successful. Many of them have been hampered by flawed designs. In general, they're very ad hoc. They happen in some places and they don't happen in others. And moreover, in my view, when you compare the overall cost of conflict, of investing in warfare, with the resources that are invested in the humanitarian effort and in the rebuilding effort of broken societies, it really highlights the inadequacy of transitioning to sustainable peace. So without just compensation, innocent civilians are impacted by armed conflict, and their grievance, I believe, continues. So today, the conversation is going to turn in particular to outlining some of the provisions in international humanitarian law and international human rights law that affirm the rights of individual citizens in armed conflict, and outline the obligations that warring groups have, particularly as it relates to reparations. I'll introduce our speakers for that in a moment. We're going to also present some theoretical approaches to peace and reconciliation and practical examples of lessons learned in peace and reconciliation work, in particular understanding the role that truth, justice, and reparations can play in transformation from armed conflict. Next week, we'll be looking specifically at concrete examples where reparations and compensation programs have been enacted within nation states, between nation states and innocent civilians, from multilateral efforts directed at individuals, enterprises, and other entities. And then we'll also have time next week to discuss next steps. What are constraints? What are opportunities? How can this be changed? How can more of a victim-centered approach to these problems? How can they be forged? What needs to be done, basically? So today, I'm very, very proud to introduce two of our really eminent speakers who will be addressing the first issues about the rights of innocent civilians and the obligations of warring groups. The first person I'd like to introduce is Professor Elizabeth Silvia Salmon Garate. Professor Salmon is a very eminent Peruvian legal scholar. She's currently a UN Special Rapporteur on the situation of human rights in the Democratic People's Republic of Korea. She's a graduate of the Pontifical Catholic University of Peru, and she's currently a tenured professor there. And she did her PhD at the University of Seville in international law. She'll be sharing this session with her colleague and I believe her student, which is wonderful, who is also with us, Juan-Pablo Perez-Leon-Acevedo, who's currently at Oxford University pursuing a DPhil in law. His thesis title is Reparations for Mass Atrocities at the International Court of Justice. And Professor or Dr. Perez-Leon-Acevedo has a broad expertise in public international law, international criminal law, international human rights law, international humanitarian law, as well as international courts. He's served in a number of diverse capacities with the International Criminal Court, with the International Criminal Tribunal for former Yugoslavia, as well as the United Nations. So we'll have that presentation that will last us around 20 to 25 minutes, and then we will follow up with the second item and presentations. And we're hoping at the end of it, we'll have a little bit of time to deal with Q&A. So thank you both, Elizabeth and Juan-Pablo. It's so wonderful to have you with us.
Thank you. I'm truly grateful for the invitation to participate in this panel, compensating innocent civilians impacted by armed conflict, which has such distinguished speakers. I congratulate the Peace Academy of Violence, particularly Steve Hollingworth, for holding this important and extremely timely event. Let me start by saying that states must investigate and prosecute human rights violations that amount to crimes under national or international law. This obligation derives from the right to remedy any person whose rights or freedoms are violated under Article 2 of the International Covenant on Civil and Political Rights. States parties are required to ensure accessible and effective remedies for these individuals and to bring those responsible to justice. Regarding international crimes, genocide, war crimes, and crimes against humanity, the state's obligation to investigate and prosecute is provided by several treaties, the 4 Geneva Conventions of 1949, the Convention on the Prevention and Punishment of the Crime of Genocide, the International Convention for the Protection of All Persons from Enforced Disappearance, and the Convention Against Torture and Other Cruel, Inhuman, or Degraded Treatment or Punishment. The duties sought to investigate and prosecute such crimes are enshrined in customary law and jus cogens norms, which apply to all states. I think that the main goal is to address what I call a culture of impunity and transform it into one that respects the rule of law. It is widely recognized that states must provide reparation when they are responsible for violations of the rules of international law, as has been consistently held in international case law. We have the draft articles on responsibility of states for international wrongful acts adopted by the International Law Commission that seek to formulate, by way of codification and progressive development, the basic rules of international law concerning the responsibility of states for their internationally wrongful acts and the ensuing legal consequences, in particular, content on reparation for the harm caused by such acts. Article 31 establishes the principle of full reparation, according to which a state bearing responsibility for an international wrongful act must make full reparation for any material and moral damage caused by that act. However, there are ongoing debates about the role of reparation in addressing the consequences of armed conflicts, because reparation for the victims of atrocities has mainly or traditionally been examined from the perspective of international human rights law. Some authors hold that international humanitarian law, I mean the international law applicable to armed conflicts, I quote, has not evolved at the same pace as international human rights law, end of the quote. However, let me be clear. Reaching international obligations under IHL, international humanitarian law, entails international state responsibility and individual criminal responsibility. Furthermore, as obligations arising from IHL, such as those set out in Article 3, common to the Geneva Conventions, I mean non-international armed conflicts, refer to parties to the conflict. IHL also links armed groups involved in hostilities to other groups or states. This means that non-state armed groups must also undertake to comply with IHL. Our hypothesis is that there have been significant new developments in reparations for victims of atrocities that are part of or specific or relevant to IHL. Increasingly, IHL is incorporating reparation for victims of serious violations of IHL as one of its core components, adding an essential reparative purpose to its more traditional and better known preventive and punitive purposes. These recent developments are evidence, I think, of a gradual transformation of international humanitarian law. They include broad recognition of the right of victims of serious violation of IHL to reparation, to the consideration of subjects of IHL other than states, such as non-state armed groups and individuals as parties required to provide reparation. Thirdly, the consolidation of innovative domestic reparation mechanisms complemented or supervised by regional courts, as evidenced by experiences in Latin America. And finally, the International Criminal Court reparation system as a global mechanism with jurisdiction over reparations for victims of serious violation of IHL, as emerging practice shows. The development of the notion of reparation within the normative and practical framework of international humanitarian law centered on repairing the harm caused in international armed conflicts got off to a shaky start. In IHL, individuals were intuitively considered beneficiaries but not holders of rights. They were regarded as objects of protection, but not actual subjects of IHL. Relevant treaty-based IHL provisions on reparation are Article 3 of the Hague Convention number 4 of 1907, respecting the laws and customs of war on land, and very important, Article 91 of the protocol additional to the Geneva Conventions relating to the protection of victims of international armed conflicts of 1975, first additional protocol. Article 3 of the Hague Convention provides that a belligerent party which violates the provisions of the same regulations shall, if the case demands it, be liable to pay compensation. Additionally, according to Article 91 of the first additional protocol, parties to a conflict shall be liable to pay compensation for violations of the Geneva Convention and the protocol, the first additional protocol. Furthermore, the commentary of the International Committee of the Red Cross on this specific article, it states that this obligation applies to all parties to an armed conflict, and those entitled to compensation will generally be parties to the conflict or their nationals. Traditionally, these IHL treaty provisions were interpreted as giving rise to obligations between states, the fulfillment of which was owed only to other state parties in armed conflicts. Only after IHL ventured beyond the interstate-state sphere, increasing the focus on people in a humanization process, did some experts consider that IHL could recognize the rights of individuals. The ICRC commentary on Article 91 of the first additional protocol clearly confirms this. There is, as yet, no provision like Article 91 in treaty law applicable to non-international armed conflicts that establishes an obligation for all parties to such conflicts to provide reparation. However, Rule 139 of customary international law, applicable in both international and non-international armed conflicts, stipulates that, I quote, each party to the conflict must respect and ensure respect for international humanitarian law. Furthermore, the ICRC recognizes in Rule 150 of customary international humanitarian law that practice indicates that non-state armed groups must provide reparation for harm caused by violations. This state-centric approach was based on the fact that most IHL treaty provisions expressly stipulate state obligations and do not encapsulate them in the language of rights. However, I think numerous precepts and prohibitions in IHL treaties require not only the protection of individuals, but also expressly refer to rights, liberty, claims, entitlements, and guarantees in relation to individuals. Consequently, the preparatory work and the telos of the Geneva Conventions suggests that the possibility of individual rights under IHL should be considered more seriously. In any event, the International Criminal Court is now established through recent practice as a global mechanism where victims of serious violations of IHL can exercise the right to reparation. These ICC and hybrid criminal courts, such as the extraordinary chambers in the courts of Cambodia, determine individual criminal responsibility for serious violations of IHL, which constitute war crimes. In these courts, the victims of such violations and other atrocities committed during armed conflicts can claim and receive reparation ordered against convicted individuals. Some contemporary international instruments also include provisions on reparations for victims. For example, the Rome Statute of the ICC, the Article 75, the 2006 International Convention for the Protection of All Persons from Enforced Disappearances, and the 2019 International Law Commission draft articles on prevention and punishment of crimes against humanity are part of the growing trend towards the identification of an individual right to reparation for serious violations of IHL and other atrocities committed during armed conflicts. An instrument that has made a crucial contribution in this area is the basic principles and guidelines on the reparations for victims of gross violations of international human rights law and serious violations of IHL, adopted by the United Nations General Assembly in 2005, which affirmed the right of victims of serious violations of IHL to full and effective reparation. Although this instrument is not legally binding, I think it reflects a strong consensus among stakeholders, including states. It marked an important step in the evolution of the right to reparation. It served as the conceptual catalyst that brought together the views of victims, civil society, the United Nations, regional organizations, and states. Finally, academic positions on reparations for victims acknowledge the existence of a customary individual right to reparation for serious violations of IHL. Most academics consider that the victims of serious violations of IHL are entitled to claim and receive reparation. Based on international and national practice, some authors recognize victim-centered approaches and the existence or emergence of a right to reparation with substantive and procedural content. In conclusion, I think it is not a stretch to concur with those who, considering that individuals are subjects of international law, conclude that a customary right to reparation has emerged for victims of serious violations of IHL. This is also practicable owing to the loose wording of IHL provisions. Although they were not initially interpreted in this way, a different interpretation can be adopted today in light of changing circumstances and new developments, and according to the principle of the dynamic understanding of the law. Furthermore, the same or similar developments in international and domestic practice concerning entitlements of victims of serious violation of IHL and other atrocities committed during armed conflicts to claim and receive reparation have also occurred in international human rights law and international criminal law. It isn't easy, I think, to accept that this situation should be any different under international humanitarian law. Thank you. Thank you for your attention. And now it's Juan-Pablo. Thank you.
Thanks for the invitation. I will address 4 complementary points. The first one is the obligation to provide reparations for victims of civilians of these atrocities imposed on non-state armed groups. There has been an increase in practice in the last decades, which is manifested via, for example, a number of resolutions of the Security Council, the United Nations General Assembly, fact-finding missions, in which those obligations address not only states, but also non-state actors. Moreover, there have been a number of examples in which there have been agreements signed by states and also non-state armed forces in regions as diverse as Latin America, for example, Colombia, Guatemala, El Salvador, the DRC, and Southeast Asia. So there is then an increase in recognition of this obligation, and there are several grounds for justifying it theoretically, including, for example, the fact that these groups are or can be considered as subjects of international law and therefore have obligations, including the duty to redress. Another ground is, of course, that they, in many circumstances, exercise control over territory and population. And finally, that states that become parties to treaties automatically bind all members of the population, including certainly members of these non-state armed groups. A second point is the effect of customary IHL Rule 150, produced in 2005 by the ICRC, which establishes that states have the obligation to provide reparation for the injury or hard cause. That has been based in a very extensive study that took approximately 10 years, but it's interesting to note that the ICRC has kept updating and expanding the sampling of practices in the last almost 20 years now. So, and in those examples, there has been the inclusion of, for instance, different national legislative instruments, case law, and also pleadings of states when litigating before international and regional courts. However, in 2005, the ICRC wasn't that categorical concerning the already existing rule imposing an obligation to redress on non-state groups. Nevertheless, that was a state of the art in 2005, and increasingly more scholars agree that at least there is an emerging rule which indicates that non-state groups also have the obligation to provide reparations for victims of serious IHL human rights law violations. A third point is about the processes or institutions which are related to the exercise of a civilian's right to reparations. Professor Salmon already mentioned some of those examples. I will just add that in the last decades, human rights courts have taken a very progressive approach, especially Inter-American Court of Human Rights, providing reparations for victims of human rights violations, which, however, took place in the context of internal armed conflicts. In the context of Europe, that situation had also included the context of international armed conflicts, even in interstate litigation. And talking about interstate litigation, a crucial development took place in February 2022 when the International Court of Justice delivered its first reparation judgment in a mass atrocity case, Congo versus Uganda. Even though the beneficiaries of the reparation is, by definition, a state, the DRC, however, the court took note explicitly of the DRC representative pledge to set up a trust fund or a kind of fund to distribute the 325 million US dollars in favor of Congolese victims and their communities. So it's important to take care, to follow up on that development. There has been already some ongoing implementation. At the national level, of course, we had a number of developments ranging from, for example, universal jurisdiction litigation in US courts to ambitious and comprehensive national reparation programs, such as the ones in Colombia and Peru, all the way to criminal litigation in national courts that can lead to compensation and other remedies. My final point is about what are the obstacles that are hindering the exercise of this right of victims to reparations. I will focus on more substantive law issues because in the next panels, there will be examples concerning many institutional and procedural aspects. I may identify 4 substantive legal problems. The first one is that although there has been an important process of recognition of the rights of these victims, the rights of these civilians, still many sources, many institutions, especially the traditional ones, talk about obligation. So even the ICRC studies, Rule 150, phrases that rule not as the right of civilians to reparations, but instead as the obligation of the state to provide reparations. That may sound like a nuance, but it still is a very crucial, in my opinion, difference, because the obligation of the states can benefit not necessarily in that understanding, in that interstate understanding, victims, individuals, but can benefit other states. It can benefit other subjects or actors of international law, international relations. So I think that it's crucial to move from a language which is centered around obligations, which is, of course, is necessary, but in my opinion, insufficient, to a language that is explicit and not shy about saying, here we are here not only talking about obligations, but also victims or civilians' rights. A second problem is the situation of victims rights as claimants or beneficiaries. Claimants, by definition, involve a more proactive role, the possibility for a victim to file proceedings, to trigger all the machinery at a national, regional, or international level. That is different from, for example, just being a beneficiary of a reparation award, which, for instance, in the context of the ICJ's case that I mentioned, that would be the only possible role, a secondary and accessory role for the Congolese victims, that they are still waiting for state implementation action. There's there an important point, which also has to do with a victim-centered approach to reparations. A third point is the controversial issue of the so-called dual status victims. So individuals who suffer harm resulting from serious IHL or human rights law violations, but those same individuals may have also be involved in commission or perpetration of atrocities. One of the most common examples is the terrible situation of child soldiers who were originally victimized by being recruited and enlisted and used in many wars around the world, but at the same time, unfortunately, these child soldiers, later adults, committed very, very serious atrocities. So that is very controversial, and any institution and process must also address the situation of these contingents of victims or individuals and do it in a balanced way, not to lose legitimacy. Final point, or final problem, is the scope of harm to be redressed. It's virtually impossible to redress all the huge, humongous universe of victimhood and also harm inflicted in this context of mass atrocities. And an example is that, for instance, in the context of core-based reparations, those victims, those civilians, will only receive awards based or limited to what the court has said happened after very high evidentiary thresholds. That almost never reflect the real scale and dimension of harm. Thank you. I can flesh out, of course, in the Q&A section.
Juan-Pablo, thank you very much. And Elizabeth, thank you. I want to point everybody's attention to a recent article that was published by both Elizabeth and Juan-Pablo, Reparations for Victims of Serious Violations of International Humanitarian Law, New Developments. It was in the International Review of the Red Cross. We do have access to a small bibliography if people would like it. I would just add, in my experience, I worked both in international long-term development as well as relief. And working in international development, it's essentially about creating opportunities for the poor. Whereas what I experienced in armed conflict was that victims had opportunities denied, they had agency strangled. And certainly the language that both of you use, and the highlights that you're saying you're making about the progress in terms of changing from object to subject, recognizing the rights. It really is about reclaiming, assisting civilians caught in the middle of armed conflicts to reclaim agency, which is a very big casualty. I'd like to turn now to an old friend of mine, Mohammed Abu Nimer. Mohammed is going to address the issues related to practical approaches of peace and reconciliation and theoretical guidelines about how that work is done, in particular understanding what role reparations can play in transformation from armed conflict. Mohammed really he's an expert in conflict resolution and dialogue for peace. He has an enormous body of practical work and research and writing on not just peace building and conflict resolution, but in particular interfaith issues. He's a professor at the American University. He's an Abdul Aziz Said Chair for International Peace and Conflict Resolution. He's also the founder and president of Salam, a peace building and justice institute in Washington, D.C. He's worked in numerous conflict zones around the world: Palestine, Israel, Egypt, Northern Ireland, Philippines. Mindanao, Sri Lanka, and the United States. And he's the author of 13 books and numerous articles on peace building and reconciliation and interfaith dialogue. His newest book is called Faith-Based Peace Building Challenges of Practice. And I'm very proud to tell you that Mohammed just received the 41st Nawanu Peace Prize Award in Japan. And he's recently back from Japan, I believe, having lectured extensively, spoken extensively, and I hope also having been feted a little bit for his wonderful work all over the world. So Mohammed, thank you very much for joining. It's great to see you.
Thank you. Thank you. Thank you, Steve, for the warm introduction as well as the recognition. Much appreciate that. And also, indeed, just to, to echo what Colin, if I'm allowed to use your first name, Colin, mentioned in the beginning regarding the timely discussion and the thematic exploration of this topic as well. And it's an honor to be part of the Welsh Academy initiative. And it's great that you're looking at the the first, you said, European Peace Peace Academy or recognition to be a peaceful space as well. I'm really, it's hard to talk these days about victimhood and reparation and all of this in the context of the war in Gaza and what's taking place in Israel and Palestine in that sense. But I'm committed to this work, and I thought this is a space that need to be both supported and nourished, as well as, maybe taking some risk and talk about these issues right now in the midst of the genocide that's taking place and all these debates regarding the ceasefire as well and ending the war. As our two colleagues, Dr. Salmon as well as Dr. Perez-Leon mentioned, there's no shortage of international laws, and there's no shortage in international humanitarian laws that probably this is something that we human in general have achieved in the past 50 or so years, where there is enough recognition for the need to compensate, for the need to do reparation, and even to present these things not only on individual level, but on a collective level. And I think it's great to continue and again list comprehensively. I look at the article and it's very, very useful to map the gaps and the shortcoming, even with the existence of the ICC and all the different decisions. At the end of the day, obviously, the enforcement remains and continue to be the primary obstacle. And within the first 2-3 minutes of this webinar, there has been already a question posed about, what do you do if there is no recognition of these international laws, no enforcement, and no, President Biden just said around 8 in the morning, we do not recognize the ICC decision at all and the procedure, and that's really where the challenge is. But again, as I said, I'm not international law expert. I am a peace and conflict resolution expert, and I teach reconciliation and peace building. And what I'm about to share with you is not the legal aspect, maybe complementary to the legal aspect, because at the end of the day, I believe that any decision regarding reparation, any legal decision regarding reparation, or any practical one requires a political decision, require moral and ethical commitment on the part of all parties involved in the conflict to be made. And hence it is a political, or because it is political decision, there is a need to look at the politics of the conflicts, especially those that are intractable conflict, like one that have a very intractable dynamic, deep-rooted conflict. And the first thing for us really to look at about advancing the concept of political recognition for the need that reparation will be taken seriously, systematically, institutionally by the political parties or the parties to the conflict, we need to understand a little bit of the dynamic and the causes of the conflicts, of these conflicts, and maybe we can generate some ways to pressure these political parties. And as Steve said in the introduction, correctly, maybe we can learn from some lessons from the history of many of these political conflicts and intractable conflict that came across or been developed. Apartheid South Africa, the war in Gaza, the indigenous people in Australia and New Zealand, as well as Native American in the US and African American slavery cases are only few of those core cases that we call intractable conflict dynamic. And like many other conflict dynamics, there are certain causes, root causes. Without addressing those root causes of the conflict, it will be very difficult to generate any political will in order to engage in a conversation of reparation of civilian victims. Whether it is during the war or after the war, regardless, we need that political will and political decision to be made. So I'm going to share three main root causes that prohibit the emerging of a political decision or an environment, a discourse between the parties during ceasefire discussion or even after ceasefire discussion, even once they construct an agreement. These three root causes of the conflict prevent, prohibit, block the imagination and the will, moral, ethical, political will of parties to engage in that. The first one is usually the notion of the fact that there are structural violence system, and the structural violence system in place continue to generate violence, continue to generate conditions on the ground that basically generate damages, victimhood on daily basis. The apartheid system in South Africa produced 19 million Black people went in prisons throughout since the 60s, at least. The structural violence system is a system of laws, regulations, norms, a political governance system that ensure domination of one group over the other, and hence basically generates victimhood on daily basis. As I said, the occupation and the apartheid in Gaza, as well as the West Bank that has been since 1967, has produced a system on the ground that have, millions of Palestinians have been subject to this victimhood, civilian victimhood, throughout those since 1967. We see the massive destruction taking place in Gaza in some kind of a live stream as an example of the structure of violence that rely on weapon, on arms, in order to settle and ensure domination of one group over the other, territorial domination that is, or extraction of resources. So these root causes, whether it is the slavery system that we have had or colonial practices that were implemented on indigenous people around the world for centuries and for decades, leaves behind a mass number of people who are feeling victims. And that sense of victimhood is really transmitted and conveyed to the next generation. So if you look at Gaza today, with 2/3 of the houses are destroyed, over almost 40,000 people known being killed, and over 10,000 still killed, yet no one can get their bodies out of the rebels that we have, destruction of the homes, women, children, starvation, all universities destroyed. Over 200 professors and doctors have been intentionally targeted and killed. The entire infrastructure leaves behind it 2.3 million people as victims. These are all, or let's put the overwhelming majority of them are civilians, and the ICC have recognized to a large extent that there is a case for the genocide to be investigated. That structure of violence in its pure form, inflicting intentional damage and targeting civilians. This is not a question of collateral damage formula, but it's really a campaign designed to eliminate certain group from existence, something that indigenous people in the US have faced, as well as African American through several centuries in the US. How do you handle that? The mass scale of victimhood is really requiring a shift in the second cause of the conflict that has to do with culture of violence. Structures of violence feed into the creation of culture of violence in every conflict. This means that the masters of the structure of violence system produce narrative and discourse of culture of violence. It spreads the notion that the use of violence is the only way to address the conflict issue between the parties. The use of violence becomes justified and rationalized by members of the communities involved as well. Today, you could see that this justification in the ultra nationalist Zionist group, especially the religious one, who are in the government and justifying publicly mass killing in Gaza. As part of this culture of violence, there is central factor of denial of all forms of victimhood of the perpetrator, whether in Palestinian side, African American side, indigenous side as well. Any recognition of victimhood by the perpetrators is perceived to be acknowledgement of the need to take responsibility over the damage and also to be held accountable. Therefore, it's denied. The third component I'm going to highlight that prohibit and prevent political will, prohibit the recognition of civilian victimhood, is the notion of dehumanization of the enemy. Structure of violence, culture of violence are based on the spreading of the concept or practice that the enemy is not a human. When the enemy is not a human, this allows the perpetrator to carry out systematic and excessive use of force in the war, as well as a full political ideology to be created. South Africa, Zionist expansionist, American settler colonialism, all of these ideologies have been created to provide just moral, ethical, and political justification for the different practices in the past few centuries. We can learn from these cases that this is really one of the crux issues that prohibit the political will, both in locally, domestically, nationally, as well as in the region. So that dehumanization can be only countered by the working on the acknowledgement of victimhood on all sides, not only on one side, but in all sides, looking in a proportional way and acknowledging that there is a process of dehumanization and need to stop. I only selected those three core factors, but there are obviously many other factors that can be grouped into them. But we, in order to unlock any of this conflict toward sustainable peace, reconciliation, as this webinar intending to do, there is a need to find a conflict transformation framework. We need to find mechanisms and arrangement that facilitate new relationships to involve the conflict, the parties in the conflict, the communities in the conflict. It's not a matter of putting a number of money and amount of resources only to be dealt with compensation. There is something wrong in the core aspect of the relationship of dehumanization, culture of violence, and militarization, as well as structures, legal, structural forms of violence as well. And that's a problem. We have seen it in so many conflicts around the world. We've seen it in Rwanda. We've seen it in the Balkan. We've seen it in Latin America in a number of cases as well. And it is impossible in general. Once we look at this, it becomes really very difficult to put a price on the extraction of natural resources, the price for achieving political domination over these populations. It generates, as I said, generational trauma, generational civilian victimhood. Just to speak to any Palestinian today, and they will immediately go back to the 1948 Nakba catastrophe took place. Speak to Native American person in the US. Although we have our rules and regulation and civil rights movement, still people go back to the Wounded Knee, still they go back to different historical period where there have been clearly victimized, as well as you can speak about the apartheid system. What can be done in the next few minutes, just to talk about, you know, what can be the pathways toward reconciliation. And knowing that it's impossible to calculate in a fair or just way the scale of compensation or reparation for the suffering and the loss of civilian in these cases. Although in the case of Germany, with the Holocaust of the Jewish, especially also people who live in Israel and outside, the German government have taken some of these measures. So there are examples in history where collectively governments have taken national decision to do reparation for some of these cases. Spain have taken some decisions to do some reparation, even to Jewish people who can trace their ancestry to the period of the 1490s in Spain, and providing Spain and Portugal, providing even citizenship or residency for the people who can trace their ancestry to that level.
Mohammed, don't feel under pressure to stop at the time. We have a little bit extra time on the Zoom, so you can continue.
That's the best gift you can give to a speaker, especially academician. Thank you. So, you know, we need really to talk about some of these issues. The compensation, it's very hard to measure, but despite that, more important than the problem of measurement of this, it's important to look at the pathways to reconciliation and sustainable peace. And those can happen with meeting the basic human needs that connects justice, peace, and reconciliation. We cannot talk about reconciliation without providing sense of justice. In the core of justice, we have moral, ethical reparation, and we have also tangible reparation. So we cannot we cannot de-link those three from each other. The sense of justice, I'm not referring here to absolute justice, eye for an eye, but the sense of justice in the process of reconciliation, we know historically, need to be changed. So those refugees who left the Balkan area in Bosnia, as well in Rwanda, victims, as well as indigenous people, African American, apartheid system victims in South Africa, needed to adjust their sense of justice. Adjust it means to be negotiated in a way to ask the question collectively, what is it that you need in order to feel that there has been some justice for your sense of victimhood? This is the core question that needs to be tackled. Of course, the legal aspect is very important for that. We need different cultures and different reconciliation approaches. We need to recognize that to reconcile and to call for reparation, and as part of reconciliation, we need to take into consideration that cultures are different. And whatever works in New York might not work, or certainly does not work in Indonesia or in Africa. And we should not be imposing our templates and measures from the North on the South. There is no one generic method to do reconciliation and reparation. We need to take into consideration economic, political, social, and psychological factors in each of these conflicts. We cannot arrive to reparation because this is a joint decision. Reparation is not done by one side only. It requires the different sides to engage in a dialogue, conversation on the necessary conditions. So it's a joint decision that dialogically it need to be negotiated among the groups as well. It involves utilizing spiritual and religious elements also in it. And finally, on this issue of reconciliation, it is a gradual, slow, and complex process. If you don't believe me, just look at South Africa, look at Northern Ireland, and look at Israel-Palestine. The three cases have had major breakthrough, political one in the early 90s, and here we are almost 40 years later, and still struggling in all the three of them, particularly in the Israeli-Palestinian one, or look at the African-American struggle to end racism and the reconciliation between white and black in the US, and you can understand how complex and how slow and gradual this process is. But in the core of it, it's a political decision. And unfortunately, until today, the United States is still struggling with the notion of reparation, despite all the discourse of civil rights movement, despite all the discourse, on accountability and denouncing slavery. Still, the issue of reparation require more political will by the different political groups that are dealing with this. It has impact on jobs, education, freedom of expression as well. It has lots of implication in that sense. But in its heart, it requires a change in the discourse of inclusion, to diversity, to human dignity, to replace the discourse of dehumanization. And then the application of reparation will be a major force in feeding into reconciliation, rather than it's a matter of resources, rather than it's a matter of tangible amount of money or resources to be distributed. Let me just move in the last section regarding the actual, what does it mean to receive reparation and restitution? And of course, we have symbolic and we have tangible forms of reparation and restitution, but both of them are designated to convey message of a process of peace building and reconciliation. They can produce four outcomes. One, reparation mean the acknowledgement of the wrongdoing. Reparation mean holding the perpetrator accountable. Reparation mean contribute to the prevention of preventing repeating the offense. So the perpetrator cannot really, or kind of pay the price for not repeating, will not be able to repeat the same offense. Fourth, reparation means support victim in restarting their life with tangible resources to compensate for tangible losses, what Steve was referring to in his work in relief and development as well. Those are four possible outcomes, messages out of reparation. Reparation is not about revenge. It's quite the opposite. It's about rebuilding relationship. It's about rebuilding the human life, human suffering in any conflict. Unfortunately, the political agreements that we have had in South Africa, Israel, Palestine, as well as in Northern Ireland to some extent, all three of them failed in many ways to fully achieve the above four conditions of reparation in terms of acknowledgement, accountability, or support. In fact, in the three of them, there was some kind of amnesty or avoidance of holding anyone accountable, and therefore no reparation were even put on the table in a collective or individual way for any of them. In the South African apartheid, they abolished apartheid, but symbolically convey the message of justice, but did not provide any tangible compensation. American political system failed totally to provide any tangible compensation for blacks, although after emancipation from slavery, they were promised, and until today, there's many circles of discussion of reparation. Those continue to be point of conflict, point of disagreement, and feed into racism and racial division, polarization in the society as well. Today, we still hear about the claims of indigenous people and the call for restitution and compensation. And it's not a matter only of billions of dollars. There are billions of dollars involved, but there is an issue of a problem of wealth and disparity. When you destroy the entire region of Gaza, you have basically held 50, 60 years of wealth disparity and created it on the ground. How reparation going to deal with that? How are you going to provide a path to rebuild the wealth in that sense? So beyond the number and the scales to measure proper compensation for the loss and the damage of civilian, it's important to acknowledge the following lessons. One, without any form of compensation or reparation or restitution, there will be no genuine reconciliation or peace in conflict. We know that from thousands of years of human history and civilization, and from at least 200 years of modern conflict history. We know without that, you will not find genuine peace and reconciliation. We know that the primary function of the principle of reparation is to generate sense of justice and security, that there is a public acknowledgement by the perpetrator and their institution of the damage and the wrongdoing that they have caused. The destruction of Gaza, as I said, and the military is a crime that need to be acknowledged and held accountable. Without reparation and restitution for the Gaza and for the Palestinians in that context of their homes, there will be no genuine reconciliation. The Israeli government can provide reparation for its citizen. The Palestinian Authority can provide reparation for their own citizen. That's understandable with the economic means that each side might have. However, the issue is for the joint reparation, joint agreement on reparation, on restitution. That's where the key for reconciliation lies. Therefore, even if third-party reparation are paid by third-party group, in the case of Israel-Palestine, they might get some Arab or Muslim rich countries to pay the bill, again, or any other United Nations agency. These are actors who cannot replace the need for holding the perpetrators accountable to its crime. So they become just a mechanism to help people rebuild their life. Important, yet it does not feed into the reconciliation in many ways. Reparation and restitution become another lesson, become also meaningful and the base for reconciliation when the post-war agreement is based on 3 principles outlined above for the reversing of the structural violence, culture of violence, and preventing dehumanization. When political agreement feed into fighting, preventing these 3 mechanisms from existing, then we can see reparation more effective and more meaningful in that sense. The political agreement has to be formulated in a way to acknowledge the equal rights for freedom, for dignity, for all people involved. Only then reparation, restitution become meaningful for sustainable peace. Finally, we should not repeat the mistake of the past in which we rebuild the houses by third party or by agency who have no link to the recognition of the perpetrator wrongdoing. On the contrary, denial and lack of accountability continue to be expressed, will continue to be expressed, and we see classic example by the Israeli official these days regarding Gaza. Reparation ought to be incorporated as part of the large, just political agreement and not a payment to silence the victims. Thank you. Thank you, Steve, for the extra time.
No, Mohammed, thank you very much. Thank you. Just a simple recap, if I can, of today and leading on to what we'll discuss next week. Thanks very much to Professor Salmon and to Dr. Perez-Leon-Acevedo. Hopefully the international community and the rights that all of us as citizens enjoy, right, are turning towards ensuring greater agency, greater accountability that's being offered, to victims of armed conflict. We're hoping for that. Mohammed's first comment in his presentation was enforceability, and we're gonna, I'm sure, get to that. How's it going to be enforced? Mohammed, thank you very much for highlighting that really reparations, compensation, it's a part of addressing a much greater structural, societal issue about victimization, about the political power dynamic, about the need to of domination of one group or another, and how that perpetuates a sense of grievance, right? Next week at the same time, we'll be meeting. Please join us. We're going to have a presentation by three external experts. The first is Dr. Marcus Shulzke, who's done significant research on the U.S. military compensation program. It's a very interesting example, and one I think that offers a lot of questions and comments. We're going to be joined by Professor Luke Moffett from Queen's University, Belfast, who has tremendous experience he's a law professor, tremendous experience in programs related directly to compensation and reparations in various contexts. And then finally, we're going to be joined by Mojtaba Kazazi, who is a very eminent independent appraiser of these situations, and he was the former executive director of the United Nations Compensation Commission for Kuwait, which is one of the shining examples of a major initiative for compensating victims. So Mojtaba Kazazi, thank you very much for staying with us all this time. And I really do look forward to seeing everyone at this time again next week. We're going to finish up with a conversation on basically what can be done, what are important next steps that need to be taken to build on this conversation. So thank you very much, one and all, and look forward to connecting next week. Diolch yn fawr iawn, Colin and Bethan. Diolch yn fawr. Thank you.
Thank you.
Thank you.